Hi, good morning, ma'am, and good morning, participants. Welcome to this oral rounds of the second National PIL Drafting Competition being organized by the Society for Constitutional Law Discussion and CNLU Legal Excel. With the prior approval of your ma'am, should we start?
Yes, we can start.
Okay, ma'am. I am admitting TC33 and then we can start.
Okay.
TC33, turn on your camera and you can start.
You are not audible. Hello? No. Why don't you try without the headphones?
Am I audible to the Honorable Bench?
Yes, you're audible now.
Is the voice clear now?
Yes, it is.
Ma'am, should I keep my mic like this only or should I wear my
That's
headset?
okay. That's perfectly fine. You can go ahead.
Should I start?
Yes.
Okay. Greetings to the Honorable Bench. The Council seeks permission to collectively address the bench as Your Honor.
Go ahead. Granted.
Indeed, Your Honor. If it may please Your Honor, the next 15 minutes shall be my endeavour in this Honourable Court, wherein the Council is appearing on behalf of the petitioner in the present matter of Vedansh Goyal versus Union of India, civil petition number XYZ of 2024. Your Honor, the present public interest litigation has been filed under Article 32 of the Constitution of India in the case concerning Section 62, Clause 5 of the Representation of People Act 1951. Your Honor, the issue before the Honorable Court is that whether Section 62, Clause 5 of the Representation of People Act is constitutionally valid or not. Your Honor, for the convenience of this Honorable Court, the Council has divided this one main issue into 4 sub-issues, which will be argued subsequently. Your Honor, if the Honorable Court is well versed with the statement of facts, the Council seeks permission to begin with the contentions.
Please give me the basic facts.
Sure, Your Honor. Your Honor, if Your Honor may please refer to page number 8 of the Memorial for Applicants. Your Honor, as a report on Prison Statistics India 2022, published by the Ministry of Home Affairs National Crime Reports Bureau, a total of 5,73,220 prisoners were confined as on 31st December 2022 in various jails across the country.
Council,
Your Honor,
sorry.
the number of convicts. Your Honor, your video has been paused. Your Honor, your video had been paused. If you could
Yeah, I
repeat
know.
what
I'm
you have said.
sorry. There was a power issue, so I just got
Yes.
disconnected. I hope I'm audible now. I'm sorry
Yes.
again. Please let me know the paragraph you're referring to.
Your Honor, I'm
You're talking about a
referring to the
report, right?
first
So just
paragraph.
point that. Page number
Yes,
8,
Your Honor.
paragraph number.
1, Your Honor, statement of facts, memorial for applicant.
Okay. Yes. Go
Yes, Your
ahead.
Honor. Your Honor, the number of convicts, under trial inmates, and detainees were reported as 1,33,415, 4,34,302, and 4,324, respectively. Your Honor, the number of under trial prisoners has increased from 4,27,165 in 2021 to 4,34,302 in 2022, which have increased by 1.7% during this period. Your Honor, paragraph number 3, statement of facts. Under trials in India enjoy various legal and constitutional rights. Your Honor, however, by the virtue of Section 62, Clause 5 of the Representation of People Act of 1951, persons confined in one prison, or two, those in lawful custody of the police are not allowed to exercise their right to vote. Your Honor, there is a proviso attached to this section which says that nothing in this subsection shall apply to persons who are in preventive detention. Henceforth, Your Honor, the statute creates a classification amongst persons in lawful custody and persons in preventive detention. Your Honor, this Honorable Supreme Court of India in Anupul Pradhan versus Union of India in 1997, it was a three-judge bench judgment in which the Honorable Supreme Court held that right to vote, in which the Honorable Supreme Court had held two things. Firstly, that right to vote is a statutory right and hence it is bound by the limitations of the statute. Let's say, for instance, if Representation of People Act 1951 is conferring you the right to vote, Representation of People Act 1951 will tell that when you do not have the right to vote. And secondly, Your Honor, it also held that the classification amongst these two sects, that is lawful custody and preventive detention, is totally valid under the provisions of Article 14 of the Constitution of India. Your Honor, multiple petitions have been filed before the Honorable Supreme Court of India challenging the constitutional validity of Section 62 Clause 5 of RPA 1951. Most recently of which was Aditya Prasanna Bhattacharya versus Union of India, civil petition number 462 of 2019, and hence the similar writ petition in the present issue, with the issue that whether Section 62 Clause 5 of Representation of People Act RPA is constitutionally valid or not. If Your Honor is pleased with the statement of facts, the Council seeks permission to begin with
Please
the
proceed.
contentions.
Please proceed.
Yes, Your Honor, it is humbly submitted before the Honorable Court that Section 62 Clause 5 of the Representation of People Act is not constitutionally valid due to the following reasons. Your Honor, for the convenience of this Honorable Court, the Council has divided this issue into four sub-issues. Firstly, that there is a right to be presumed innocent. Secondly, the Council will focus on the concept of indivisibility of human rights. Thirdly, Your Honor, the Council will try to contend that how as to this classification is against the reformative theory of punishment. And lastly, that how India should draw inspiration from other global countries. Your Honor, first and foremost, a fundamental postulate of criminal jurisprudence is the presumption of innocence, meaning thereby that an accused is innocent until proven guilty. Your Honor, it means that an accused is innocent until he is proven guilty, and that too beyond a reasonable doubt. A division bench of the Honorable Supreme Court of India has labeled this presumption as human right in the case of Narendra Singh and others versus State of MP. Your Honor, however, these are the fundamental canons of a criminal jurisprudence, and they're quite in conformity with the constitutional mandates that have been enshrined under Articles 20 and Article 21 of the Constitution of India. Your Honor, furthermore, the Apex Court of India has held that the presumption of innocence is embedded in Part 3 of the Constitution, not only as a part of rule of law under Article 14, but also as a part of Article 21. Your Honor, it is a well-settled and adopted position of law that everyone charged with a criminal offense shall have the right to be presumed innocent until proven guilty according to law. Your Honor, this can be drawn from Article 1, Clause 1 of the Universal Declaration of Human Rights and Article 14, Clause 2 of International Covenant on Civil Political Rights. If Your Honor may kindly refer to the Compendium 14 Code 33, page number, Your Honor, 15.
50?
15, Your Honor, 15.
15. Okay, 15, right.
Yes, Your
Honor.
Article 11, Your Honor. Everyone charged with a penal offense has a right to be presumed innocent until proven guilty according to law in a public trial at which he has had all the guarantees necessary for his defense. Your Honor, if you may also refer to page number 17 of the same compendium. On the last of the page, Article 14. Article 14, Clause 2, which has been marked in green, Your Honor. Everyone charged with the criminal offense shall have a right to be presumed innocent until proven guilty according to law. Your Honor, now coming back to paragraph number 4, page number 12, memorial for applicants. It is humbly submitted before the Honorable Court that persons in lawful custody or else confined in prison have a right to be presumed innocent until their guilt is proven beyond a reasonable doubt. Your Honor, this undermining principle of criminal law is very fundamental in nature for the protection of rights of an arrested person. The denial of voting rights to persons who are not convicts is a brazen violation of this principle, Your Honor. So, Your Honor, this brings me to the end of my first sub-issue. If there are any preliminary queries, Your Honor.
No, not right now.
Okay, Your Honor. Your Honor, moving on to the second sub-issue, that is indivisibility of human rights. Your Honor, in this sub-issue, the council will try to balance two rights of an under trial. Let's say, for instance, there is an under trial person X. Under trial person X has a right to bail under several statutory provisions, which shall be contended in the subsequent issues, and he is not allowed to exercise his right to vote, both of which rights are human rights, and the council will argue that how as to these human rights are indivisible in nature and they have to be placed parameter to one another. You're on a page number 12 of the memorial for applicants, indivisibility of human rights. Firstly, paragraph 1. Every under trial has a right to be released in bail if he or she has served half the maximum sentence in prison. Your Honor, this is as per section 479 of the Bharatiya Nagarik Suraksha Samhita. Your Honor, moreover, the Honorable Supreme Court of India has held that under trial prisoners charged with murder can be released on bail if the cases are pending for 2 years or more. Also, Your Honor, the scope of the right to bail that has been conferred on the under trial has been further expanded by the Apex Court, where an under trial prisoner was for more than 10 years, against whom 48 criminal cases were registered, was furnished with this right to be released on bail for the enforcement of his fundamental rights. So, Your Honor, what the council is trying to contend is that if an under trial prisoner has a right to be released in bail, which has been opined by the Honorable Supreme Court in so many cases, then how can an under trial be denied such a right which is so fundamental to the functioning of Indian democracy, that is the right to vote, more so when his guilt has not been proven in the Honorable Court. Your Honor, this brings me to the second right, that is right to vote. Your Honor, as per Section 62, Clause 5 of the Representation of People Act 1951, as stated previously also, persons confined in one prison and two in lawful custody of the police are not allowed to exercise their right to vote. Your Honor, in the context of modern legal jurisprudence, both these rights, one right to bail and two right to vote, in its most primary form are human rights. The council agrees that they are statutory rights and they are bound by the limitations of the statute, has also been opined by the Honorable Supreme Court in Anupul Pradhan vs. Union of India. But Your Honor, before statutory rights, these rights are human rights which are vested with under trials and thus ought to be placed parameter to one another. Denial of one right invariably impedes enjoyment of another right. Your Honor, the Honorable Supreme Court of India has held that a right to elect, fundamental though is to the democracy, is anonymously enough neither a fundamental nor a common law right. It is purely a simple and statutory right, and the council agrees to the opinion of the Honorable Supreme Court. But what the council is contending is that before statutory rights, right to bail and right to vote are human rights which are vested with the under trials. Your Honor, in Anupul Pradhan versus Union of India, what the Honorable Supreme Court of India says while denying this right to under trials, what reason they state? In the judgment, the reason that they state is that it would be very difficult for all the under trials in terms of resources and everything to get them out of the lawful custody and like they can exercise their vote and then place them back in the custody. It would be very tedious for the administration. Your Honor, but the council contends that a resource crunch and the practical difficulties in allowing prisoners to vote is not a valid justification for the denial of a right. Granted that rights are not absolute, but they can only be restricted on reasonable grounds, and which resource crunch is not a reasonable ground, Your Honor. Your Honor, this brings me to my third sub-issue, which is that how is this principle against the reformative theory of punishment? If Your Honor may refer to page number 14 for the memorial of applicants, paragraph number 1 and paragraph number 2, Your Honor.
Please tell me the page number once more. Page number?
1-4, memorial for applicants. Yes, Your Honor. Your Honor, what the council will contend in this paragraph 1 and paragraph 2, Your Honor, the one that has been marked in yellow, Your Honor.
Okay.
Yes, Your Honor. Your Honor, what the council will contend here is that the judicial courts in the country or the Indian criminal justice system follows a reformative theory of punishment. Reformative theory of punishment is based on the belief that human nature is capable of reform and that the object of punishment is not to inflict retribution but to reform the offender. Your Honor, this fact is further cemented by the addition of the punishment of community service in the Section 4, Clause F. If Your Honor may refer to page number 8 of the compendium, the one that has been marked in green, Your Honor, Section 4, Clause F, community service.
Okay. Marked in which color?
Green, Your Honor.
Green.
Punishments.
Okay. Yes. Got it.
Yes, Your Honor. So, Your Honor, when the Bharatiya Nyaya Sanhita 2023 has added a community am I audible? Am I audible, Your Honor?
Yes, yes. I'm really sorry about the
I guess there
internet
was
problem.
a technical glitch. Your Honor,
Yeah, please.
now moving to paragraph number 3, page 14,
I'm
memorial
sorry,
for
Council. Can you
applicants.
please go back? Can you please go back to the idea of community service? After that, I lost you.
Yes, Your Honor. Your Honor, if Your Honor may refer to page number 8 of the compendium, Section 4 of the Bharatiya Nyaya Sanhita, under Section 4,
Yes.
Clause F, a new form of punishment that is community service has been added, Your Honor.
Okay.
Your Honor, what the council is trying to elucidate by stating this is that if post conviction, the judicial courts in the country tend to follow a reformative approach, then this should be the scenario at the pre conviction stage as well. Your Honor, for example, if an under trial is not allowed to exercise his rights, which are so fundamental to the functioning of Indian democracy, and post conviction, the judicial courts tend to follow a reformative theory. Then, if post conviction, a reformative approach or a approach which aims to rehabilitate the position of the offender in the society is followed by the judicial courts, then that should be the approach of the criminal justice system pre-conviction as well. This is what the council is contending by cementing the fact of community service. If it satisfies the question, Your Honor.
Okay.
Yes, Your Honor. Your Honor, this brings me to the last issue. Your Honor, if the council can have a time extension as
Maybe for another 3 to 4 minutes maximum.
okay, Your Honor. Your Honor, if Your Honor may refer to page number 15 of the memorial for applicants, memorial for applicants under the heading Global Inspiration.
Yes.
Your Honor, in this, what the council will try to contend is as to how India should draw inspiration from these countries and foster a legal system wherein all the human and legal rights of persons, whether under trials or behind the bars, are safeguarded and protected. Your Honor, first to start with Canada. In Canada, every citizen has a right to vote in an election of member of the House of Commons or of the Legislative Assembly and to qualify for membership therein. Your Honor, this was opined by the courts of Canada in the landmark case of Saw versus Canada, footnote number 32. Your Honor, in South Africa, a similar position has been followed, and it has been followed that the principle of universal adult franchise is enshrined in the Constitution of South Africa. Furthermore, Your Honor, the judicial courts in Australia had found that disenfranchising all the prisoners was arbitrary, as it did not account for the severity of the crimes, taking into account that imprisonment does not necessarily indicate serious criminal activity. Your Honor, in United Kingdom also, the ECHR, that is United Court of Human Rights, ruled that a blanket ban on British prisoners exercising their right to vote is contrary to the European Convention of Human Rights. Your Honor, if Your Honor may refer to page number, just a second, Your Honor. If Your Honor may refer to page number 48 and 49 of the compendium.
Okay, yes.
Your Honor, speaking of the High Court of Australia, in the landmark case of Roach versus Electoral Commission, page number 49, paragraph number 133, the one that has been marked in yellow.
Mm-hmm.
The High Court of Australia has held in Roach versus Electoral Commissioner that universal suffrage is now a historical constitutional fact in Australia, protected by the requirement in the Australian Constitution that the Senate and the House of Representatives be directly chosen by the people. Your Honor, since the government is by the people, so it includes all the peoples, whether under trials or behind the bars or pre-conviction, post-conviction, all sorts of people are included.
Okay, Counsel,
If
please
Your
conclude.
Honor,
Please conclude your argument.
yes, Your Honor. Your Honor, hence a right as fundamental as the right to vote should not be dependent on the status of imprisonment or conviction. And this brings me to the prayer that wherefore in the lights of issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court may be pleased to declare that Section 62, Clause 5 of the Representation of People Act is not constitutionally valid, all of which is humbly prayed before the honorable court by the Council for Appellants, TC 33.
Okay. I just want to revisit your prayer.
Yes, Your Honor.
Hmm.
Your Honor, the prayer is on page number 17,
No,
Memorial for Appellants.
I don't want to see the memorial. You just tell me in one single line what is your prayer.
Your Honor, it is humbly prayed before the Honorable Court that Section 62 clause that the Honorable Court may be pleased to declare that Section 62 Clause 5 of the Representation of People Act 1951 is unconstitutional in nature due to the
Okay.
reasons that have been cited above.
I'll stop the council here. I want to know whether you want the entire subsection to be declared unconstitutional or a part of it.
Your Honor, the Council wants the entire subsection, that is Section 62 Clause 5, to be declared as unconstitutional because Section 62 subsection 5 creates a classification between two sets of persons, which the Council has contended is against the principles that have been enshrined under Article 14 of the Constitution of India. If it satisfies the
Okay.
question, Your Honor.
Okay. If we revisit subsection 5, then it says no person
Yes.
shall vote at any election if he is confined in a prison. That's a very wide phrase, right? Confined
Yes.
in a prison is not only about under trial prisoners, but also about anyone who has been imprisoned after following the proper procedure of law. So why do you want to get the entire subsection declared unconstitutional? And for the entire argument, you have talked about primarily about under trial prisoners.
Thank you for the question, Your Honor. The Council seeks permission to answer the question.
Go ahead.
Much obliged, Your Honor. Your Honor, but I agree that there's too far a gap the Council is trying to bridge. And to bridge this gap, Your Honor, I agree that I've talked of under trials. Your Honor, but there are two sets of people. If Your Honor may refer to subsection 5, that no person shall vote at any election if he is confined in a prison or is in the lawful custody of the police. So, Your Honor, my contentions are for both the persons who are confined in a prison or who are in the lawful custody of the police. So your Honor, the persons who are in lawful custody of the police and the persons who have been confined in a prison, their guilt has yet not been proven beyond the reasonable doubt. And
What makes you believe that lawful custody of police is not after imprisonment? Give me a clarity on that.
Your Honor, I agree that the police has a role and duty to maintain the law and order. And if the police is arresting a person, there's a prima facie case against him, all the charges. Your Honor, but let's say, for instance, if today, 29 September, 5, 4:45 p.m., I get arrested by the police. Tomorrow, 30th September, 5 p.m., the general Lok Sabha elections, the polling for the general Lok Sabha election ends at tomorrow 5 p.m. Today, I am being arrested at 4:45 p.m. The police takes me in custody. Your Honor, your video is paused. Your Honor, your video is paused.
Ayush, am I audible?
Your video
Ayush,
is paused, Your Honor. Am I audible?
am I
Yes, ma'am.
audible to you?
Yes, yes, ma'am. You are audible. Very well audible.
Okay, thank you so much. Counsel, please go back to the last statement you have made. You are not audible to me.
Am I audible now, Your Honor?
Yes, you're audible. You're audible now.
Yes, Your Honor. Your Honor, so let's say, for instance, if 29th September, 4:45 p.m., I get arrested by the police. 30th September, 5 p.m., the polling for the general Lok Sabha elections for the year is ending. So if I get arrested at 4:45 p.m., I agree that this is a prima facie case against me. I've done some actions. My code of conduct in this society has been such that the police thought in their fullest wisdom fit to arrest me. But Your Honor, if I get placed before the magistrate tomorrow 4 p.m., or let's say if I get placed before the magistrate tomorrow 4:30 p.m. as per Article 22 of the Constitution of India, and the magistrate sets me free. 4:30 p.m. I'm being freed. 5 p.m. the polling closes for the general elections, Your Honor. So I was just arrested merely based on some accusations, and now there is no reasonable time for me to go and exercise my such a right, which is so fundamental to the functioning of Indian democracy and the elections which will come post 5 years. So I'm
Okay,
talking about
understood.
those persons.
Understood. I have two more questions. I'll talk about the more fundamental question first. You have talked about community service as a punishment, right?
Yes, Your Honor.
And you have been referring to the under trial prisoner and their right to vote. And you have connected the right to vote to the idea of reformative theory of punishment, right? That's what I have
Yes,
understood.
Your Honor.
So my
Yes, Your
question is, if they're under trial prisoners, how are you saying that they should get community service? That's the kind of punishment, right? So that means they have already done something wrong. Their guilt has been proven, hence the punishment or the sanction is being imposed. But if they're under trial, how can you talk about the punishment part?
Thank you for the question, Your Honor. The council seeks permission to answer the question. Much obliged, Your Honor. Your Honor, what the council was contending by bringing in the point of reformative theory of punishment and the community service was that the fact that the judicial courts in the country tend to follow a reformative theory of punishment has been further cemented by the parliament of the country by
Counsel,
adding
counsel, please understand the question. I am not doubting your argument. I'm just trying to get a clarity on the fact that community service should replace that that we are imposing a ban or we're imposing some kind of sanction over an under trial person to cast a vote.
Your Honor, your video is paused if I am audible or not. Am I audible, the organizing committee? If
Yes, yes. This is 33. You are audible. Let ma'am rejoin.
Yeah, please go ahead.
yes, Your Honor. Your Honor, what the council is contending is that if the judicial courts in the country tend to follow a reformative theory of punishment, the approach of the court is that the mindset of the offender or the position of the offender in the society has to be regained in the society. This is one side. The other side, what the council is contending is that if post conviction a reformative approach is applied by the judicial courts, then pre conviction, prior to the pronouncement of the sentence, if the person is the under trial person or he's in the lawful custody, also also a reformative approach should apply, and a reformative approach cannot be applied if
Counsel,
rights of a
reform,
person are
counsel, get the question. Counsel, please, I have a very different question. See, reformative approach or reformative theory of punishment is about a sanction. Right, once the guilt is proved, then only you can talk about reforming. The person has done something wrong, hence you're trying to reform the person. But when you talk about an under trial prisoner, you don't even know whether he is guilty or not. Correct? So why are you talking about reformation? If the person is right, if there's a fictitious case, if there is a wrongful allegation against the person, we are yet to look into that part. So how can this argument stand?
Your Honor, if the council will again contend that if post conviction a certain approach of the court is followed, or the Indian criminal
I
justice
understood
system
your
follows
point.
an approach
I understood
post.
your point, counsel. My concern is
Yes,
different. Reformation comes for a guilty mind. Someone who may have done the crime or may have done the wrong or may not have done the wrong. For them, we cannot from the very beginning take reformative approach. If the person is right, what exactly are we trying to reform?
Your Honor, but denying such rights which are so fundamental to the functioning of the world's largest democracy, pre-conviction, that is right
I'm
to
still
vote, and the
convinced with this argument. This line of argument I am not convinced with. Anyways, let's move on to the last question. We're running short of time. You have compared the scenario, Indian scenario with Canada, South Africa, and Australia. Can you give me one good reason for each jurisdiction? Why we should compare ourselves with them?
Your Honor, it is humbly submitted that the council is not contending that India is lagging behind in terms of political scenarios or democracies. We are the world's largest democracies, Your Honor, and India, the council is contending that India should only draw inspiration from these countries and foster a legal system wherein all the human and the legal rights of persons, whether under trials or behind the bars, are safeguarded and protected.
No, see, counsel,
Your
if
Honor,
you
what
want to
makes me
compare, if you want to really draw inspiration, there should be a line of similarity between the jurisdiction, right? So I just want to know how you are putting India and South Africa, India and Canada, and India and Australia in a similar position. Give me that one example where you find that our legal jurisdictions are quite similar and we should borrow from them or we should take that approach.
Your Honor, all these countries have progressed in their legal judicial system. Not that India has not progressed, but since these all these countries have crafted the widest possible interpretation of the right to vote and have adopted it as well. So India should also craft the widest possible interpretation of this right and should adopt the same as well. And Your Honor, India is also a signatory to the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, which Your Honor may refer to the compendium for Teen Code 33, page number, Your Honor, page number 15 and page number 17, which Your Honor has also referred previously about the UDHR and ICCPR. So, Your Honor, this rests on India an unsaid responsibility to shape this sphere of human rights in the most progressive manner. And in order to establish a society where higher standards of human dignity are met, India should extend its arms, welcoming a wide arena of rights that are to be furnished upon its citizens. The council is not comparing, or the council is not stating that India is far behind those countries or India should be placed parameteria to those, but it's just that since those countries have crafted a widest possible interpretation of a certain right which India has not, and India and the judicial courts in the country have also opined that this right is a statutory right, which the council also agrees. But before statutory right, in the context of modern legal jurisprudence, these rights are human rights which are vested with the under trials, and they should not be debarred from exercising these rights. If it satisfies the question, Your Honor.
I think that's all. Nothing else from my side. Ayush, can we wrap up this session, this particular session? Ayush?
Yes, ma'am. Yes, ma'am. Yes, ma'am. We can.
So
I'll
can
allow
we?
another team to join.
I'll need around 2 to 3 minutes, and then we can take the other team.
Yes.
Is that okay? Yeah. Team 33, you can leave. Thank you for joining us and all the best.
Thank you, Your Honor. It was a pleasure arguing before the Honorable Court. May I be of any further assistance to this Honorable Court, all of which is humbly prayed, Team Court 33.
All the best.
Much obliged, Your Honor.
Just give me one more minute.
Well,
I'll just
sir,
update.
okay,
Sorry.
okay, okay, okay. So should we allow TC34 to join, or
Just give me 1 minute.
once you
Let
tell
me
me
update the sheet.
to let? Okay, done, done.
Yes, we can call the next one.
All right, ma'am.
Am I audible?
TC34, you can start.
Yes.
Okay. I would be starting in a count of 3, 2, 1. Good morning, Your Lordships and my Ladyship. The Council, although in this video conferencing format, acknowledges the presence of the Honorable Bench. However, for the sake of brevity, the Council seeks the kind consent of the bench to address the bench collectively as Your Lordship.
Granted.
Much obliged. Your Lordship, I am Harapriya Patel, and I am the petitioner, and I have filed this public interest litigation before the Honorable High Court of Odisha. Uh, the council now, I am submitting my own case, and I seek permission to kindly proceed with the briefing of facts.
Go ahead.
Much obliged. Your Lordship, Bhubaneswar is the capital city of India's eastern state of Odisha. Now, Odisha was formerly known as Orissa. Now, Bhubaneswar is a capital city, and in the last few decades, it has seen tremendous growth and in different sectors. Now, in Bhubaneswar, we have the Bhubaneswar Municipal Corporation, Your Lordship. Now, the Bhubaneswar Municipal Corporation spans across an area of 200 square kilometer and has around 67 municipal wards. Now, the BMC or Bhubaneswar Municipal Corporation also has the duty of maintaining the cleanliness and sanitation of the city, as well as the collection of solid wastes from door to door and streets to its disposal. Now, Your Lordship, what has happened here is that over the last 2 decades, Bhubaneswar has seen tremendous growth. And along with this growth, Bhubaneswar has also seen or experienced an influx of population. Now, population from different parts of Odisha as well as different parts of India. Now, Bhubaneswar had a population of 8,37,737 as per the 2011 census. Now, the 2021 census has not been published, but according to the Bhubaneswar Municipal Corporation, it is around 1.3 million or 13 lakh. Now, this increase in population, increase in infrastructure has also resulted in the increase in waste generated in Bhubaneswar. Now, according to BMC, there are 15 lakh waste generators in Bhubaneswar. 13 lakh is the original population, and 2 lakh is the floating population from different parts of the state as well as from different parts
Source
of.
of your data.
Sorry,
What is the source of your data, council?
Your Lordship, the source of this data is from the affidavit that was filed by BMC before the National Green Tribunal, which I would be dealing with just in a few minutes.
Okay.
Your Lordship, I would like to mention, Your Lordship, right now as well. Now, this accumulation of waste has created a lot of problem for different people in and around Bhubaneswar. Until 2023, the city's waste was being dumped at Daruthan dump yard. Now, after non-treated waste and less managed waste being dumped at a particular site for several years, this led to public agitation. Now, at that point, the BMC was compelled to create a TTS or temporary transit station at Gadakana, which is also in Bhubaneswar. Now, what has happened is that in the same site in the TTS, that is Gadakana, the same problems were faced as well. Now, this led to the petitioner, that is myself, and it compelled me that I went to BMC. Then I went to the Odisha State Pollution Control Board, but I did not, I was not able to get any adequate response. After that, on the basis of an article published in the Times of India, I filed an application before the National Green Tribunal, Eastern Zone Bench. The Eastern Zone Bench, National Green Tribunal, took the suo motu complaint of that application and also constituted a fact-finding committee. Now, this case went on until 8/8/2024 or 8th August 2024. The information that I have been presenting till now is on the basis of the affidavit which was filed by BMC after being notified by the National Green Tribunal Eastern Zone Bench. Now, the problem is the National Green Tribunal, after getting the results from the fact-finding committee, gave the order and also disposed the case on 8th August 2024. But the order which was given said that there should be processing of the legacy waste present in Bhubaneswar by March 31, 2026. But Your Lordship, the order did not address several key issues regarding the accumulation of waste at TTS as well as the further hazardous effects which we are facing, the residents of that place are facing as well. So this has compelled the petitioner to file a public interest litigation before this Honorable High Court of Odisha. And I have filed this case purely on the basis of for public interest and without any private gain. Now, if Your Lordship is satisfied with the briefing of facts, the council would like to proceed with the issues raised.
Please
Uh,
proceed.
in the light of these circumstances, Your Lordship, there are three important issues that I would be raising today. I would be completing everything within 15 minutes. 5 minutes are over, so I'd be doing that within 10 minutes, Your Lordship. First, I would be submitting how this PIL, along with an interim application, which I would be dealing in issue number 3, is maintainable before this Honorable High Court. Secondly, I would also elaborate on how the BMC needs to take action to protect the rights of the citizen under Article 21. And thirdly, I would be elaborating on how and why or whether the court needs to direct the BMC by passing an interim order to stop this accumulation of waste as well as the several hazardous effects which are following due to that, Your Lordship. Now, if Your Lordship is satisfied with the issues being raised, the council
Please
would like to
proceed.
proceed with arguments
Please proceed.
advanced. Much obliged, Your Lordship. Your Lordship, at first I would be dealing with issue number 1, that is related to the maintainability of the PIL that has been filed, along with the interim application which I have also filed, Your Lordship. Now, Your Lordship, I have approached this Honorable High Court under Article 226 of the Indian Constitution, and I have filed this public interest litigation without any personal motive or with an intention of getting any personal gain. The only personal gain which I would get is if the accumulation of waste is treated properly, it is managed properly, and the hazardous effects are stopped. Your Lordship, regarding the maintainability of the petition which I have filed before this honorable court, as I have already mentioned, I have approached the BMC. I have approached the Odisha State Pollution Control Board, and I had also filed an application before the National Green Tribunal, Your Lordship. So I have
So what is
exhausted
the
all
outcome?
my.
What is the out? I'm sorry, Counsel. I just want to know what is the outcome of all these approaches. You have approached all the relevant authorities. They have not given you a chance of hearing.
Your Lordship, I did not get any adequate response from the Bhubaneswar Municipal Corporation as well as the Odisha State Pollution Control Board, but the National
Okay,
Green
Counsel.
Tribunal.
Are you giving me any kind of document which will prove that you have not received adequate or enough reasoning for not taking action from any of these authority? Do you have any such document?
I do have the documents, Your Lordship, but due to the it is an error on my part, Your Lordship, but due to the adhering the word limit, I was not able to attach the annexures. So that
But
is the
also
problem.
try to understand the Honorable High Court is really busy and there are specific jurisdictions, correct? You are talking about a duty given to the municipal authority. That's one thing, you've approached them. Secondly, you have NGT, you have Pollution Control Board. So all of them must have applied their mind. And just because you are not satisfied doesn't mean I'll be convinced to take up your PIL, right? I'll not do that. I need proper evidence that you have not been heard. Then only I can consider taking up the matter. Otherwise, why will I waste my time? There are more important matters which can be considered.
Your Lordship, I would here like to just talk about the order which was given by the NGT, National Green
Council,
Tribunal
that
Eastern
will
Zone.
not be taken into consideration because I don't have a copy. If I don't have a copy, I cannot rely upon it. It's just your word of mouth. That's not acceptable.
I bow down, Your Lordship.
So
Ma'am,
we are not talking about issue number one. We don't need to consider it because we don't have enough proof. So we can proceed to the
absolutely, Your
second
Lord.
one. Please move.
Uh, I'll do that, Your Lordship. The second issue deals with whether BMC needs to take action to protect the rights of the citizens. Here, I would be formulating my arguments or submissions on the basis of one rule and one notification. One is the order given by the National Green Tribunal in the original application number 606 of 2018, where it had issued an order directing all states and urban territories to ensure proper collection, transportation, and processing of MSW or municipal solid waste, including the commencement of biomining of wastes for land reclamation and scientific disposal of the waste. I would also here like to mention that there has been serious non-compliance of the solid waste management rules 2016 by the various industries and commercial units in and around Bhubaneswar, and BMC and citing the solid waste management rules 2016 rule number 15, that the BMC needs to delegate powers to officers or the local bodies should delegate powers to officers to levy spot fines as per the bylaws framed and the rules which have been formed. Your Lordship, in this case as well, there has been serious non-compliance of the rules framed in the solid waste management, and an order which was passed by the National Green Tribunal in the case of Harapriya Patel versus Bhubaneswar Municipal Corporation. The fact-finding committee found out that out of the 1,32,950 tons of waste, there was 56,065 tons of RDF, or refuse derived fuel waste, which was still there, Your Lordship. Now, according to the order, if the legacy waste is processed, it will be processed in March 2026, but it still has a very hazardous impact on the population present there, impact on the local environment
Still again,
of that.
do you have any evidence to prove this impact? Any
Your
study,
Lordship,
any report?
Your Lordship, I do have the
Just give me the names
studies.
of those reports. What is your source? How are you relying upon the data?
Uh, Two datas which I would rely upon is the same. In the Times of India, the article was published regarding how the waste which was there, it was creating trouble for the school students present of
So
the
you're again
locality of that.
misunderstanding. Newspaper can give me the fact, but reliability of the fact should come from authenticated source, right? So I
True.
want to know what was the source for Times. I need
Uh,
a reliable source. So please give me the reliable source. Otherwise, whatever you're saying, whatever you're arguing is nothing but mere allegations.
Your Lordship, the major another point which I was about to mention was the increase in cases of bronchial related cases in the hospitals of
Council,
that
all
area.
this are okay. All this are okay. But again, you have to understand that we are a developing country. At the same time, we are the most populated country, right, around the world. So here, our responsibilities are supposed to be taken care of with respect to proportionality principle. So quantum of harm has to be judged in the context of the resources we have. So unless and until you are showing me the data and evidence to prove that it is more detrimental than what is now, I can't rely upon your statements.
Your Lordship, the only thing that the petitioner has is raising is that with the waste that is being accumulated, the hazardous effects, although there are data which we could have attached, but this is an error on our side. But the
Council,
number of cases of
you are coming to the highest court within the state, and you're coming without data, without any evidence. Next concern is whatever you are claiming, they are already part of the duty. They are already there as a part of the duty of various organizations, including your municipal corporation. So what do you want from my side?
Your Lordship, the council prays for two things. One, that is, as earlier it was done, the another TTS be taken into consideration by the BMC so that the amount of waste can be channelized. This is one thing. Another thing is the BMC may be directed to collect fines from the industrial units so that there would be there would not be any further non-compliance of the rules. These are the two things that the petitioner is praying
It's
for.
okay, council, but my concern is first of all, I don't see any legal argument over here. You're talking about just a duty without any kind of source, any kind of data. So, as a legal forum, as a judicial forum, I need to know the legal obligations. I need to know the sections, articles, and other relevant things which are applicable in this scenario. So, without quoting them, you are just making a tea table conversation, which we don't want to do.
Uh, I bow down, Your Lordship, but here I just wanted to, the council wanted to raise the issue. Like the one thing is there has been non-compliance of the solid waste management rules. Your Lordship, secondly, due to the hazardous effects, the health of the citizens is being affected. So that is a violation of
Understood. You have
Article
already
21.
said all these things. Council, please come to the prayer portion. What is your prayer? What do you exactly want from our side? What do you want us to do for you?
Your Lordship, I will proceed with the prayer. In the light of the facts stated and issues raised, it is humbly prayed that the Honorable High Court may be pleased to declare the PIL maintainable before the High Court, pass an interim order directing the BMC to take appropriate actions to stop piling of the waste, direct BMC to charge penalty from commercial outlets and industrial units for non-compliance of SWM rules or Solid Waste Management Rules 2016, pass any
One
such
second,
orders
I'll
as it.
stop you for a minute. Do you think these rules are allowing me to impose penalty on them? Is it allowed? Is it quantified
The
in the rules?
Your Lordship, the BMC may be directed to charge
So
fines,
I'm
which is a.
asking, can BMC impose penalty on the wrongdoers, those who are polluting the environment? What is the quantum of penalty that can be imposed, and which rule of which act, under which provision it has been mentioned? Give me the quantity and the relevant provisions.
Your Lordship, I can give you the relevant provisions. The quantity, I'm not aware of, Your Lordship, but
You are claiming it, right? You're claiming something. You want to impose penalty, and you
I
don't know the quantum of penalty. How is that possible? It's not fair.
I do bow down, Your Lordship.
Which rules and which act?
In the rules, that is the same, the solid waste management rules of 2016, rule 15, where it is rule 15 subsection Z, where it is clearly mentioned that the BMC, the local bodies, uh, uh, for the local bodies prescribe the local bodies delegate powers to officers to levy spot fines as per the bylaws framed and in case of non-compliance with the rules formed.
Okay, I think that's enough. Thank you from our side, and all the best. Ayush, again, I'll take 2 minutes of time to fill the
Sure,
marks.
sure. TC34, you can leave the meeting.
Yes, we can call the last one.
All right, I'm just confirming if because she has joined with her name.
Okay, no problem. How many teams are participating?
Ma'am, for the oral rounds, we qualified 12 teams,
12
including
teams.
single and team. Yeah.
Okay. So by the end of the competition, may I know the teams I have judged? The identity of the teams?
Sure, ma'am. Sure. No worries.
Okay. Not now, after the competition. Yes.
Right, right, right. We'll share.
You are from which college?
Ma'am, I have just graduated from Chennai National Law University this year.
Okay. You are from CNLU.
Yes, ma'am.
Right.
and try to really let others know you are anything. ठीक है चलो ठीक है दिव्या मैं एक बार बोल रहा हूँ बिल्कुल सुनना है अगर
Divya sir, are you TC35? Hello?
She left the meeting.
TC35, please turn on your camera.
ओ आपका टीसी के नाम से याद है
TC35, please turn on your camera. TC35, can you hear me? Hello? TC35, can you hear me now?
Yes sir.
Please turn on your camera.
Sure sir. Sir, am I visible?
Not yet.
No, no, you are not.
I'm now.
I can't see you. You're audible.
Just a second, please.
TC35, please turn on your camera.
मेरे से देखो
Due to some certain issue, we are doing on a single PC only. Can we?
Sorry, we can't hear you.
Ma'am, due to some issues, we can't connect on one of our laptop. So can we do it with a single PC?
Yes, it's all right. I don't think ma'am will have any problem.
Yeah, I don't mind. It's okay for me. I just want to see both of you. One of you is not visible to me. Yeah, better. All good now. We can start.
All right. TC35, you can start now. Your time start.
Thank you, sir. Greetings to the bench. If it may please, this is the honorable.
You're no longer audible, you're on mute.
Greetings to the bench.
Yes, you're audible. Please go ahead.
If it may please, this honorable court. This is counsel appearing on the behalf of Adya versus State of Rajasthan and others. In this, the petitioner is appearing to the honorable court under Article 226 of the Indian Constitution for issuance of a writ in a nature of mandamus or in a nature of appropriate writ, direction. The petitioner appearing due to the violation and infringement of fundamental rights and other legal rights of the public as a whole, guaranteed under Part 3 of the Indian Constitution, mentioned under Article 14, 15, and 21. Failure on the part of state government in implementation of DPSP under Part 4 of the Indian Constitution, resulting in violation of their duty to protect SC/ST from exploitation and social injustice under Article 46 and 47 of SC/ST community. Violation of Section 16, 17, and 18 of Water Prevention and Control of Pollution Act 1974. Failure on the part of state government in implementation of National Water Policy 2012. Failure on the part of PHED, Public Health and Engineering Department.
Counsel, if you can give me the facts before you start with your claims.
Supplies, ma'am. The facts of this case are as follows. As we are concerned with the SC/ST and further marginalized because to their social and economic backwardness, these are the residents of Sursagar constituencies. The government has continuously failed to provide them with clean access to water. Plus, there are several affluent residents in that constituencies who are using illegal means like water pumps and etc. to draw excess water. And the
I have
state.
few doubts. I have few
Yes,
doubts
ma'am.
before we can proceed with the facts. First thing first, water and right to have clean water is a common right for everyone. Why are you differentiating between the general category and SC/ST class? That's first thing. Second thing is, then how can you say that water pump or using a device to collect water is illegal? How is that possible?
Much obliged, ma'am. Um, mm, Ma'am, as for the first of your doubt, the right to water is everyone's right. That's correct. But here we are generally referring to that affluent citizens of that particular area are having clean access to water and proper access to water. They are using the water pumps to draw excess water that they are not allowed, and due to which the supply to the others are affected. They
So
can't get.
is there any law in India which says that we can use only this much quantity of water? Or any law in your specific jurisdiction which says only this much quantity of water can be used by a household or by a single person?
As per the PHED guidelines, uh, they are to provide 135 liter per capita water to each household as per a scheduled time, and they have
And
failed to do so.
who
And
is
one
keeping
of
track on this amount?
yes, ma'am.
Who is keeping a track on this amount of water? Which authority?
The the Water Resources Authority as well as the PHED in Rajasthan, and also Rajasthan Water Supply and Sewerage Corporation are responsible to keep a track on this.
Okay, please proceed with the facts and keep it brief.
Much obliged, ma'am. The Sagar constituency consists of about 4,000 to 5,000 residents, and due to some affluent citizens plus omission on the part of various departments of the state, they can't get proper access to water, that is 135 liter per capita as per the PHED guidelines, and neither they have access to water on a scheduled time, that is 1 p.m. to 5 p.m. They those residents are unable to reach the court because most of them are daily wage laborers, and they belong to scheduled castes and scheduled tribes, and further marginalized due to their lack of knowledge and social and economic backwardness. So
Okay,
we
what are your arguments? Come to the issues.
the issues concerned in our case are that right to water is a right for everyone, uh, and the state has failed to comply with its own guidelines and with various acts that has infringed article 14, 15 and 21 of the citizens.
How is it violation of Article 15?
Article 15 states that uh, there should not be any discrimination uh, mm, in grounds of religion, race, caste, sex, and place of birth. Here, the scheduled caste are specially discriminated because other citizens who are belonging to affluent and they are not scheduled caste, they are reaping extraordinary benefits here, but the
Okay, please
scheduled caste
counsel.
doesn't.
Counsel. Uh, my question is, how do you know that SC/ST they are being marginalized, whether they don't get access to water and they are the victims of this whole scenario? What is the source of your information? Do you have
On
any
the
report or any such thing?
on the source of the informations are the surveys collected uh, by our team
Any,
as well as
name,
some
name
newspaper
one, name
articles.
one. And if you have used them in your petition, please let me know the page number.
Yes, ma'am. Next page.
Page number 14.
Ma'am, on page number 14, we have provided with the data of our survey collected.
Okay. Page number 14 of your petition, right?
Yeah.
Yes, ma'am.
Give me the paragraph number.
Paragraph number 13, ma'am. We have collected this survey specifically by the people who are belonging to SC, ST and other social backward classes.
Who has conducted this empirical survey?
And this empirical survey was collected by our team.
Your team means you too.
Yeah,
Yes, ma'am.
by Google form, ma'am.
And how many participants were there?
Approx 50, ma'am.
Across
50.
50, 50.
Yeah,
Yes,
ma'am.
ma'am. From each
Okay.
household. And each household has contained about 5 to 7 members. So it represents around minimum of 150 members.
Okay. Please proceed.
Yes, ma'am. So as per the survey, 72.1% of the respondents have stated that they don't have any sufficient access to water. Plus, 77.8% are not aware of the guidelines of PHED about 135 liter per capita distribution of water. And 61.4% has responded that the water quality is unfit for their consumption, which is also hazardous to their health and led to several diseases, minor as well as major diseases. And 73.9% has stated that they do not get supply of water as per the scheduled time of 1 p.m. to 5 p.m.
Okay. Do you have any other argument?
May I proceed with the liabilities that we have paused on the respondents, ma'am.
Okay, who are your respondents over here?
The respondents here are the PHED department as well as water resources department, the local authorities, and the Rajasthan Water Supply and Sewerage Corporation, and PWD, and Jodhpur Development Authority as well.
And not the state of Rajasthan?
Yes, ma'am, as well as the state of Rajasthan.
Okay, so what are your claims? What is exactly your prayer? What do you want to get out of this PIL?
In the said premises, it is most respectfully prayed that this honorable court may graciously be pleased to issue writ of mandamus or direction to the respondent to rectify the disparity in the water which is faced by the people of Sursagar, and they legally mandate the 135 litre per capita distribution of water as per the scheduled time, as well as receive for the issue of directions to the respondent to establish a monitoring mechanism that can ensure that the affluent citizen get uh, can't reap any extra benefits, and issue of directions to upgrade the infrastructure, and issuance of an order to supply water tanks to the unserved areas as a temporary measure until the pipeline system is upgraded.
Okay, again, you can't just have a generic claim, right? Uh, Improving infrastructure cannot be a prayer. You have to tell me exactly what you want from my side. I can't simply write down that infrastructure should be improved. Give me a specific prayer.
The we pray to the honorable court to issue directions to the departments, Jodhpur Development Authority, to develop the infrastructure in a way that no private motors can be attached to the pipelines, and the other affluent residents can't reap unjust benefits.
Okay. Any other claim you have? Any other prayer? Anything?
Uh, Ma'am, in India, there are the politicians which give the manifesto of river linking projects, but they are only in superficial talks and imagination talks, but they have not implant these things.
Okay. I
And
think that's
because
all
the
from my side. Please go ahead. If you want
and
to
the
add
things,
something, please.
yes, ma'am, because the manifesto with the promise which they give to the public is done by the politician, but the implementation is done by the departments, by engineers. So there is a problem in convincing the engineers why departmental issues. And there is also a money constraint because India is not a developed country. India is a developing country. So the government cannot put money, excessive money, because they have a certain budget. Rather than that,
Okay.
ma'am, in water projects, uh, there is a specific time to complete the project. There is that is 24 months. But the time taken to make the DPR, detailed project report, that itself took approx 12 months, which is more than, ma'am, 3 times to it.
Okay. I
And
think
between,
that's all from my side. Do you want to add something more? Am I audible?
yes, ma'am.
So do you have any further things to add?
No, ma'am.
Okay. So thank you and all the best.
Thank you.
You can leave the meeting. In 35, you can leave the meeting.
Thank you.
Ayush,
Yes, ma'am.
I have already completed the marks and everything. So it's a Google
Yes,
sheet, right?
yes, ma'am. Yes, ma'am.
Any other thing you want from my side?
No, ma'am. So you have done the this marking
Yes, I have done the marking.
for all the
Anything?
three teams, right?
All three teams, yes.
No, ma'am. No, ma'am. Thank you so much, ma'am, for your help.
No
We'll be
problem.
sharing the details of the participants by EOD or latest by tomorrow.
Okay. Thank you
Okay.
for giving me the opportunity. It was
Thank
nice
you so much, ma'am.
to talk to you
Pleasure is
and
equally.
conduct this competition. So thank you. Yeah. Bye bye.
Thank you so much, ma'am. Thank you so much.